Hello, friends and clients of JLW Immigration Law Group. I am Jennifer Walker Gates, board certified immigration attorney, and I'm here in this video today to talk about public charge updates in 2025. Public charge is a concept that applies to individuals who are becoming lawful permanent residents through the adjustment of status process or through the immigrant visa consular process, usually people who are applying through family members or employers. So we're going to be talking today about the status of that concept, the public charge inadmissibility concept today in this video. I want to make sure everybody has information that is based on real time, on the ground, actual facts, and not just rumors and rhetoric. So that's what we're doing. Before I get into this topic, I would like to ask you to please take a moment and subscribe. Subscribe to our channel, click on the like button, send the video to a friend or a loved one who may be going through the process if they are concerned about the public charge ground of inadmissibility and the way that is being applied right now in 2025. Please do share. We want to make sure everybody is successful, whether you are working with us as your attorneys, with a different attorney, or whether you're going through the process on your own. We want to make sure everybody has really valid, reliable information about how this process is working. So please help us do that. Share, subscribe, comment. I do respond to comments. I just ask that our audience comment safely and as anonymously as possible. All right, so public charge. I want to just, before I get into what's happening right this moment, back up to the first Trump administration when the concept of public charge was going through a lot of scrutiny. There was a lot of publicity about it. There was a lot of rhetoric about public charge becoming an impediment for many, many individuals who were trying to go through the immigration process. There was a lot of rhetoric about blocking people, making people inadmissible if they had ever accessed any kind of public benefit. And it left a lot of people very frightened and very nervous about whether they still qualified for adjustment of status or an immigrant visa through their loved one, their spouse, their child, their parent, etc. Ultimately, the rules that were passed regarding public charge during the first Trump administration were struck down as being unlawful in the way that they were implemented. So when the President Biden took office, that administration actually did publish some rules regarding public charge and how it works. They made some revisions to the paperwork that is filed on behalf of individuals who are seeking adjustment of status or who are seeking an immigrant visa, so that the public charge ground of inadmissibility is addressed more thoroughly and more completely through the applications themselves when you're actually applying. The Biden administration didn't really fundamentally or significantly change the rules that had already been in place regarding public charge. They simply modified the applications. They did modify the rules somewhat to simply restate and reaffirm the public charge standards and rules. The way that those operate, the public charge standards and rules say that an individual is inadmissible as a resident to the United States through the family-based or employment-based system. Okay, this does not really apply to humanitarian cases at all. So if you have a U visa, VAWA, Cuban Adjustment Act, asylum, a number of different humanitarian categories that are applying for adjustment of status, this doesn't apply to you, okay? This applies if you are going through the family-based process or if you're going to adjust status through an employment-based petition. So if you are doing that, the rules have always said, or since this concept was codified in law in 1996, that basically if you are at risk of becoming dependent on the government, a public charge is someone who's dependent on the government for their basic sustenance. If you cannot demonstrate that that's not going to be your situation in the future, then you're not admissible. You can't become a resident, right? The idea is that in the process of becoming a permanent resident of the United States, you need to be able to show that you have significant financial support or that you can provide for yourself effectively in the future. Okay, they don't want to allow people to become permanent residents through these family-based and employment-based processes if the government is then going to have to help sustain and support folks. Okay, so that's the idea. And the rules that are in place now are are the same as they were under the Biden administration. Those rules have not changed. The application and interpretation of those rules in the process of adjudicating applications might be a little stricter. There might be some additional requests for additional supporting documentation. There might be some more stringent application of co-sponsor requirements. Things like that may be shifting a little bit under this administration, but the rules are fundamentally the same. Okay. And those rules are that if you have not ever been institutionalized at government expense or received kind of direct cash benefits and sustenance directly from the government, then you're not automatically considered a public charge. So the use of benefits such as SNAP benefits for US citizen children of applicants, that does not lead to a public charge finding. Use of, public health insurance during a pregnancy, for example, when the US citizen child is in utero and the mom receives medical benefits for that pregnancy, those are considered benefits to the child that is going to be born, not to the undocumented or non-citizen mom. So it's important to understand that the use of benefits in one's family, okay, that was really at issue during Trump 1, is that anybody in the family's used public benefits, then that can lead to a public charge finding against anybody else in the family. Okay, that's kind of the direction that the rules were heading during that time. That did not take effect. And what is in place now says those kinds of benefits for US citizen children do not count against a parent who is applying to become a legal resident. Now, that's not to say, again, that things can't be applied and interpreted a little more strictly depending on the officer. It's going to still be very important for applicants to demonstrate the ability to sustain themselves, to demonstrate that they have members of their family and members of their community, employers, people who are willing to step up and say, we'll be responsible for this person if they can't be responsible for themselves. Because the likelihood that anyone's ever going to have to pay a cent for that person to be sustained is low. In our experience, the immigrant community is very hardworking and very actually unlikely to ever access public benefits. People who are non-citizens and non-permanent residents aren't even eligible to receive the kinds of public benefits that lead to a finding of public charge in most cases. So it's just really important to understand that whatever language may be being employed right now about strict adherence to the public charge rules and any kind of anxiety and fear that may be coming up around, am I eligible financially to do this because in the past my kids were on public health insurance or my kids were receiving food stamp support. It's just really important to understand that the current rules do not make that an automatic deal breaker. You can still qualify. You might need some additional bolstering of your financial eligibility, but that is not a deal breaker. Okay, so it's just important to keep that in mind, understand the law, understand what is really happening on the ground, what is actually happening in the legal application to these different cases, and know that even though there's a lot of rhetoric around strict enforcement of public charge, the rules are still the rules. And so most immigrants, frankly, are still able to qualify under these rules most of the time, even if they have to use a co-sponsor. Most people have a community member, most people have a friend or family member who's willing to step up and say, I support this person. I will provide financial backup if it's needed. So I hope that this helps. I hope that this information is able to provide people some peace and security about your application. If you need additional information in a private, confidential setting, please contact us and book an appointment. Our number is 512-633-1785. You can also reach us on our website at jlw.law, where you can click on a button to schedule an appointment with me or either of my partners. We will be happy to analyze your financial eligibility to become a permanent resident through a family member, as well as whatever else may be going on in your case. So please don't hesitate to reach out. Thank you again for being here. Thank you for choosing the United States as your home. We are grateful to have you. And with that, I'm going to sign off. Be safe. Join us on Wednesdays at noon for our live where we answer questions live on our YouTube and Facebook. We'll talk to you soon. Bye-bye.